Good afternoon, all. This pretrial review is in the matter of CFI 038-2023 and is being held by way of video conference before His Excellency Justice Roger Stewart, KC, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Taylor Wessing. Lead counsel is Mr. Stewart Adair. The defendant is represented by Simmons & Simmons. Lead counsel is Mr. Yash Bahiro. Thank you, Your Honor.
Thank you very much. Good morning, everyone. Thank you for your skeleton arguments and your agreed note. What I would propose to do is to just discuss briefly trial management PTR issues, then go on to the claimant's application in respect of documents, and then deal with the claimant's application for further information, unless either of you have any additional matters that you would like to raise.
No, Your Honor.
Thank you very much. So far as the pre-trial review is concerned, thank you first of all for reaching agreement on the matters in relation to that. I just want to clarify a couple of points. First of all, in relation to the trial bundle, the proposal is that it's going to be hosted on Opus. And is that definite, or is, as it were, attenders still being sought in relation to that?
My understanding, Your Honour, is that we have obtained, I think actually those instructing my learned friend are dealing with this, have obtained a quote for the price, that it is quite reasonable, or the parties consider it to be reasonable. And my understanding is that we're moving towards instructing Opus. So I think we're virtually there. I don't think it's finalised, but my understanding is that that is in train, etc., and that the parties are agreed on it.
Very good.
If I can assist, Your Honour,
yes,
my instructions are telling me that Opus have now been engaged, so I think that can be taken as confirmed.
Right, excellent. And in terms then of preparation, the effect of the orders which were previously made at the case management conference is going to be that the claimant's opening is going to be served 2 clear days before the trial, which will mean, I think, Wednesday the 5th of March, by the end of Wednesday the 5th of March. Is that right?
I think that must be right, yes.
And the defendant's opening will be a day later, which will mean by the end of Thursday the 6th of March.
Yes, Your
Honor. Very good. I mean, from the court's point of view, I will need access to the Opus bundle and documents referred to by the time that the claimant's document is served on the 5th of March. I'm not quite sure. You've given me a day's pre-reading, for which I'm grateful, but I will, I think, probably try and do a bit of pre-reading in the end of that week or the week before, so I will need access to the bundle by then.
Understood. I'm sure we'll be able to arrange that, Your
Honour. Excellent. And just in terms of the witnesses, I'm looked briefly at them and so forth. I mean, it does seem to me that we've got ample time for this trial, as really your timetable has identified, particularly as there's no expert evidence here.
I believe that's right, Your Honour. Yes, yes.
Good. Do either of you want to raise any other issues in relation to matters other than the request for information or the request to produce documents?
Your Honour, if I could just address you briefly, you will have seen that we've sort of applied a little bit of a caveat.
Yes,
to
I should have said, I do understand that you take the position that if you get a document dump, then, as it were, you're reserving your position in relation to the ability to go ahead on the 10th of March. I do understand that everything is subject to that.
I'm grateful. I mean, I should just say that on a couple of days ago, on 10 p.m. on Wednesday evening, we received 2,000 documents. and if further documents are going to be, it's a bit of a prejudicial word, but dumped on us, then there is serious question marks over the ability of the legal team, which consists of me and an associate, to deal with that and process that before the trial begins. So I see that Your Honour is mindful of that, but I just thought it was worth reiterating at this stage.
Yes, no, I understand that. I understand your position in relation to that, Mr. Adair. Well, we'll see where we get to when we've dealt with the other applications. Right. Anything? Sorry, Mr. Berry.
Apologies, John. I was just going to say there's one other point which I should flag now, which is in respect of our witness, Mr. Doug Bitcon. The proposal is he will be giving evidence virtually, given he's in the United States at the time. We may need a direction, and that may need to be reflected in the PTR order if Your Honour's content to do so. And of course, we'll make the arrangements in the usual way for the video conferencing to be set up. Yes,
Mr. Adair.
That's the first I've heard about this, so I've been somewhat taken by surprise by that. I would really want to take in some instructions, and right. Those instructing me are obviously on this trial. Sorry.
If this is the first occasion upon which this has been raised, I don't propose to make an order about it today. The facilities exist plainly for remote hearings to take place, and the court, or for mixed hearings to take place. And in principle, the court is quite happy to have a witness attend remotely, but it does seem to me that it's the sort of matter which ought to be dealt with between the parties before it's raised before the court, if this is the first time that it's happened. So in the event that there is any contest about this, I will, well, the parties better identify what the issue is, and I will make a ruling on written submissions at the appropriate time between now and the trial if there is an issue about it.
I'm grateful. I've sort of sent an email to those instructing me to see if I am correct and that this is the first we've heard about it, because I don't want to mislead the court. I've not heard about it personally. I'm asking the question, and hopefully we'll be able to advise Your Honour before the end of this hearing as to whether what I've said is correct or whether this has been broached in correspondence and I've just not been made aware of it. But I certainly have no instructions on it at the moment.
All right. Okay, well, we'll come back to that if necessary. All right, anything else in PTR matters? Right.
No.
Can we deal with the document request first? And I propose to deal with them sequentially, 6, 7, and then 8. I will hear brief submissions in relation to each of them, and I'll make a ruling on each of them as we go through. Can I just say this, Mr. Adair, because I think it'll be helpful to you. It does seem to me that if you take by way of example your request 6, which is in the bundle at 521, emails, letters and other documents relating to the nature and scope of RBL's role in the management of its funds and its investments, looks about as unnarrow and unspecific as it is possible to be. It hasn't got a date on it. It's got words relating to, and it seems to me that it doesn't fall within the proper ambit of the Part 28 of the rules. I thought it might be helpful so you know where my initial starting point is in relation to this.
No, I'm grateful, Your Honour. That is helpful. What I would propose, if I may, is if we look at that application first, which Your Honour will find at page 246 of the bundle.
Yes.
And it's actually, the wording is set out at 247, and what we're seeking is, as Your Honour has said, document requests 6, 7, and 8, and then at the bottom of that is the information requests. It is the defendant did it. We say the defendant has done its very best to delay the document production process.
You don't need to address me on delay in relation to this at the moment. I've read the correspondence. Bluntly, I think Mr. Berry's got better points in relation to this, but you don't need to address me on delay. If we get to delay, then it's going to have to be Mr. Berry who's going to be saying why it shouldn't be put forward. I've seen when you asked for it, and I've seen what the tally of responses is.
I'm grateful. The defendant makes sort of two overarching points about this. One of them relates to delay. Trial is just 1 month away, and suggests that you should then that principle should be something that directs your decision on this. The other point that it makes is that the defendant has sought to engage cooperatively with us. Now, whatever the width or breadth of document request 6, and I'll come back to that, it is quite clear that there hasn't been, shall we say, a constructive attempt to engage with us. When this, if we look at the schedule that deals with this particular request, and Your Honour will find that at page 269. So that sets out the request, which is emails, letters, and other documents relating to the nature and scope of Ribble's role in the management of the fund. And it sets out the relevance. And the first point to be made is that this is actually front and center in terms of relevance in this claim, because it goes to whether or not the defendant is the fund manager of this fund, which itself will go to the nature of the fund. It's the basis upon which they say it's not an external fund, but also more particularly to the nature of the statutory duties that are owed. If it is the fund manager, it will.
I mean, it's not in dispute that an issue, possibly an important issue, is whether or not the defendant was the fund manager for the purposes of the relevant legislation. So you can take it as read that I've got that. The difficulty I have about this is this looks like, I mean, it actually looks like worse than old-fashioned standard disclosure. And in this court, by standard disclosure, I mean Peruvian guano type disclosure.
Yeah.
I mean, this seems to me to be taking, well, I mean, it's a bit unfair to a blunderbuss, really. It's more a sort of artillery preparation and devastation of the battlefield, and it's about as far from a sniper rifle as it's possible to be. And I can't at the moment see how, when you ask for, I mean, what are the dates of this? And when do you say this should start?
What I would say is that this is driven by Article 22 of the Collective Investment Law. And what that actually provides, as I set out in my skeleton argument, is that the fund manager, and that is the issue that this goes to, is the party that establishes, manages, and winds up the fund. Now, during the correspondence that's passed between the parties in relation to this particular request, the focus has drawn onto the actual establishment of the fund. It's quite clear that this is what is relevant. That is why the suggestion that is made, and if we look at page 270, we see the reformulation.
Yeah, but okay, so the answer to my question is establishment. So that's what, yes. November 2014.
So that was, I think 2013. It was actually established.
Right. So you want these documents from 2013 until when?
Until, well, relating to, and I think what we have focused in on is the appointment of the third-party service providers, the lawyers, the accountants,
You haven't focused in on them. I mean, your request is, I mean, in your skeleton, you say you'd like various things, but there's no focus at all. I mean, how would one know whether this order had been complied with?
If one goes to page 270 and the response to the objections,
yes,
and about halfway down there, they say what we say rather is the proposal that the document request be confined to the period 5th of November to 4th of April 2019 is misconceived, because the role of the fund manager relates inter alia to the establishment of the fund and the appointment of the service providers to the fund. The role also involves the management of property of the fund, etc. Then we say in the next paragraph, in order to properly understand the nature of the managerial role undertaken by the defendant, the claimant seeks disclosure and production of correspondence relating to the appointment of Maples Corporate Services Limited, Maples and Calder Dubai LLP, Apex Fund Services Limited, Dar Al Sharia and PwC. So we have focused in there. Now, the relevance of this,
sorry to stop you, Mr. Adair, but I do have real problems about this. I mean, as I say, it does seem to me, with respect, that when one reads the jurisprudence of this court, this sort of, I mean, His Honour Judge Chadwick said the words relating to are not narrow and specific. His Honour Judge Giles has said in another case that, you know, that this sort of request is just not a request for document production. Now, if, and I'm not formulating it for you, you were to ask for the agreements between Maples Corporate Services, Maples, Calder Dubai, etc., one can see that that could be properly a narrow and specific category of documents. But I mean, you're seeking far more than that.
Well, what we're seeking, and because the relevance of those appointments has been accepted, and they have offered to provide those contracts to which Your Honour has just referred. The problem with that is if what they will be is a contract between the fund and those third-party service providers. Now, if one is to understand properly who is managing that, you know, that is the end product of it, and it will obviously say the fund engages the services of Maples, Calder or whatever. What we say is that the correspondence surrounding those contracts is what is required, and that will show that these were all negotiated by the defendant, that the defendant managed these and brought them up to the process where they were rather like a corporate service provider put before the directors of the fund who signed them. So what we are saying is this is all smoke and mirrors. What we don't need are the cosmetic window dressing documents, which will show undoubtedly that there was an agreement between the fund, the Cayman Islands company, and the corporate and the service providers. What we want to see is the correspondence surrounding that and the negotiation of that. And we say that.
But the very way you put the very way you put that suggests that what you're hoping to do is to wade through a mass of documents which is being provided in order to look for something to seize upon. I mean, that's just not the function of a document production order.
Well, in my submission, we're not looking to on some sort of fishing expedition in that way. What we're really seeking is the correspondence relating to the negotiation of those contracts. We just need to identify who negotiated them and in what capacity. It is important that is understood, because if a regulated, authorized firm within the DIFC, subject to the jurisdiction of this court, is claiming that it is not managing a fund, and in fact it is, and what we have pointed to in the skeleton argument and in the witness statement is documents which evidence the fact that is, and we've pointed to, I don't know if Your Honour has picked this up, the offering memorandum, which refers to various tasks in respect of which the defendant is entitled to claim expenses, and this involves regulatory matters instruction of third-party service providers, etc., etc. It also deals with the minutes of a board meeting of the fund, where Mr. Bitcon himself reports on how the defendant is establishing an Islamic investment platform for the fund. Now, those functions being undertaken by the defendant are the functions of a fund manager. So we know
sorry to interrupt you, but so you've got those documents. They're going to be deployed at the trial in support of your contention that the investment manager of this fund was in fact the defendant. And as it were, on your feet, although we're both sitting down, you've put forward an alternative formulation in what's got here. But I mean, there is, as I see it, an absolutely fundamental problem with, and 6, if I may say so, is the worst of your requests, which is that it's time limited. It uses very broad and general words like emails, letters, other documents relating to, and then very broad, the nature and scope of IBL's role in the management of the fund and its investments. I mean, it couldn't be much wider. Well, you've now told me that what you're really interested in is the correspondence surrounding the appointment of the firms who are in the penultimate paragraph of page 270. I mean, even that's quite broad, but I mean, at the moment, it's just not what you're asking for.
Well, I mean, I accept, as Your Honour says, that the initial request wasn't framed as sharply and as it ought to have been. I accept that. This process went on for a long time. When it came to our response to the objections, we then did narrow in and focus on what specifically was being required in a sensible way. Now, the position that is being taken by the defendants in relation to this application is, look, when we finally wrote a letter in December, on the 11th of December, we actually offered this, that, and the other. And that therefore, you know, we're satisfying the requirements, notwithstanding that their initial position was to object entirely to everything that we were asking for. So there's been some, shall we say, evolution in this matter. Now, in my submission, when one tracks through that evolution, we've come to the position where we are saying, and they understand, that we're looking for, and what I'm asking Your Honour to direct, is that the correspondence, be it emails or letters, relating to the conclusion of these agreements with these specified and identified service providers be provided. Where
do we find that formulated? Where is that set out? I mean, I've got the penultimate paragraph of 270.
That is, it's set out there, and then it is further explained, I think would be the better word. I don't think that there is, to be fair, I don't think there is a better formulation of the request, but the reasons for it and the importance of it are explained in subsequent correspondence. We wrote in November and in December on this. So I think that formulation there in the objections, which was made pretty early on, is probably the best formulation that we have. But in terms of how is this to be managed at the PTR and what can be done to ensure a just trial, my submission is that it will be formulated as the correspondence relating to the conclusion of the engagement of those specified service providers. That in my submission is sufficiently well focused. And it's important that you know the court is equipped to decide the issue, a central issue, when we come before Your Honour in March to deal with this matter. As I've said, there is the offering memorandum. There are minutes. They tend to show. I mean, what the response is going to be: the offering memorandum entitled the defendant to reclaim expenses. They will probably say, well, there's no evidence that we have reclaimed expenses. The minutes of the board meeting are slightly stronger in that they show that the defendant was actually undertaking the construction of an Islamic investment platform. But what we want to actually see, and we are confident that if we see these communications, this correspondence, it will show that that this was all being done by the defendant within the DIFC.
Have you got the agreements under which Maples Corporate Services, Maples and Calder Dubai, Apex Fund Services, etc., are appointed? Do you actually have the agreements between the funds?
I suspect they may be in the last glut of documents that has been sent to us.
Right.
That there were 2,000 documents.
So you'll know the dates of those documents.
I think that's right, and I'm sure that in any event the defendant will tell us what the dates of those documents are. But yes, I believe that they may well have been sent. As I've said, 2,000 documents were sent the other night, and it's simply not been possible yet to actually evaluate them and read through and identify precisely what they were. I was sent this morning, I have to say, by those instructing me, an Excel spreadsheet listing those documents, but it was provided to me about half an hour ago, and I've not had an opportunity to go through it. I think my learned friend wants to say so.
If it assists, apologies for interrupting. The corporate contracts you're referring to, Your Honour, were in fact provided in January. They're not part of the recent batch that was given a few days ago. They were provided much earlier.
That was 16th of January. I think we received some documents then. Okay. So yes, we will know the dates.
All right. Now, and as I understand it, what you're wanting is the correspondence leading up to those appointments between, I assume, the defendant and each of Maples Corporate Services, Calder Dubai, etc.
Yes, Your Honour, yes.
And it seems to me that correspondence, I mean, I don't know what the dates of these agreements are, but it's likely to be possible to time limit that before each of those relevant agreements. So maybe that they're all entered into at the same time. I've got no idea.
Yes, I mean, it's common ground that the dates which are pleaded in the pleadings are when the fund was incorporated and established, and it is our assumption that very shortly thereafter all the service providers were appointed. As Your Honour says, the dates of those contracts which have now been provided will identify when each of them was actually formally appointed, and will delineate the sequence, shall we say, or the time scale between the establishment of the company and their appointment will be the time limit.
Okay. All right. Do you want to say anything more in relation to this request, Mr. Adair?
If you bear with me, just I check my notes as to what I might say, because obviously we've curtailed and Your Honour has truncated by identifying the issues and the problems that you had, exactly what needs to be said. I just want to make sure that there is nothing that I have in my notes that really needs to be relayed. Yes, I think only to say that there has been an attempt, we say, a somewhat obtuse attempt to narrow this down unrealistically in terms of focusing on the date of 2018 to 2019, which is unrealistic.
We've moved
okay.
away from that.
Okay. I think we have now focused throughout the correspondence and now in front of Your Honour on exactly what we are seeking, and I don't think there is much that can additionally be said other than that they have provided those contracts which establishes that they accept their relevance. They will not tell us anything useful. It has to be the correspondence surrounding them. I think that's all I need to say.
Right. Ms. Biru, you can take it as read that I'm not going to grant the original request And you can also take it that your recitation of the overall principles upon which document production orders should be granted, well, I was going to say has been read and understood, but it is something upon which the court is very alive. What do you say were I to permit the claimant effectively to reformulate this request 6 so that it was the correspondence between the defendant and each of Maples Corporate Services, Maples and Calder, the entities which are set out on page 274. Yes. I'm minded at the moment to think that there ought to be a date limit before the entry into the agreements. In other words, it would be time limited for, I don't know, 2 months or something before those agreements were entered into. Yes. What do you say about that alternative formulation if I were to permit the claimants to make it?
Yes. Well, firstly, I've taken on board Your Honour's observations, and I'm grateful for that indication. I'm not going to go too much into the criticisms that have been levelled at us about constructive engagement and so forth. That might be an issue that's relevant later on. What I would say in respect of that, Your Honour, is obviously this is a new formulation, so I would need to take instructions on how feasible that would be. Because if we're talking about correspondence that goes back to the incorporation of the fund, we are talking about 12 years. So I don't know to what extent it's going to be difficult or what data is still retained or how easy it is to search it or how it's stored. But leaving that to the practicalities of that to one side, Your Honour, I would nonetheless invite you to dismiss this request. I'm not going to focus on, as it were, the old request, but what I will say is that the request that's before the court now, all 3 of them in fact, are unchanged from when the original requests were made back in August and when we objected to them on the 12th of September. And there's only been one party that has been willing to either suggest alternative formulations, which we did in our objections in respect to number 6, as well as offer additional documents. We have never taken issue with the relevancy, we've taken issue with the scope. So Your Honour has the point about the broadness of the current formulation. The second reason that we do object and we say a further order is not necessary is that we have, subsequent to the objections coming in, provided further documents that fall into 5 separate categories. Now, that is set out in my skeleton argument, Your Honour, at paragraph 22.1. Should you want the reference in the bundle, it's at section I, document 2, page 688.
Sorry, can you just give me the paragraph for your skeleton argument?
It's 22.1, Your Honour.
Yeah.
Now, those 5 categories of documents which we have agreed to provide in addition to whatever we have disclosed encompasses a number of further documents. First of all, they are the meeting packs and the minutes of the directors for the fund from the period November 18 to 4th of April 19. Now, my learned friend says that date is unrealistic, it's unfeasible, they don't understand it. I will explain this. That date range represents the initial approach with ALAWWAL right up until the point of where they invested into the fund. Now, the way in which the claim is formulated is they say we are the fund managers and we acted as a fund manager. It's an allegation we deny. However, they say that because we are the fund managers, it gave rise to certain duties, and they say we breached those duties as a result of actions that we undertook in that period that induced them into entering into the investment. So we say it must be material then what our actual position and what we were doing during that period of time. And that's why we focused in on that date. But I can understand. Sorry, I can understand why you focused in on that date, but surely before that, how the fund was in fact operating
before that date is going to be material to how it was operating between sorry, I've now lost the dates, but between the end of 2018 and the investment in 2019.
Not necessarily, Your Honour, because what the claimant says and what my learned friend says is he relies on Article 20, and he says, well, that sets out certain things that categorizes you as a fund manager. Yeah. And it may be helpful to actually look at it. It's quoted at paragraph 51 of my learned friend skeleton, so very helpfully, yeah. Which is, if Your Honour has it separately, it's page 16 of the skeleton. If you're looking at it in the bundle, it's
I'm looking. I've got the bundle and I've got each of your skeleton arguments separately. So I'm sure. Looking at it separately.
Yes, page 16 of my learned friend skeleton at paragraph 51.
Yeah.
So if I can just invite Your Honour, before I address you on it, to read the quoted extract.
Is the quote accurate? Is that should that be legally accountable?
I don't have it. I do have the law in front of me, Your Honour. If you bear with me 1 second, I can.
Yeah.
Yes, it should be. Yeah, you're right, Your Honour. It's not an accurate quote, but I think the gist of it is right, accurate.
Okay. Yeah.
Now, what the claimant says is because Article 20, the identity of the person establishing the fund is relevant to who the fund manager is. Disclosure shouldn't be limited to that time, and it's the point Your Honour has picked up on. But I have 3 submissions I would make in respect of that.
Yeah.
The first one goes to the actual formulation, i.e., if the focus is on that, then it doesn't match up with the formulation. But Your Honour has that point.
Yeah.
The second is that the fund was not established by the defendant in any event. It's in fact pleaded within the amended defence that it was established by a different entity, which is RASMALA Managers Limited, who established the fund. That's already pleaded at paragraph 20 of the defence. So it's not Ribble, as it were, who established the fund. So there may be some issues there that we actually need to go in and take a look at. But the third point is, in order for a party to be a fund manager, it's not actually a requirement that that entity establishes the fund. As Your Honour can see in the wrongly quoted, but the gist of which is right, but at 51, it provides that a person who manages the fund, i.e. as a fund manager, is someone, first of all, who is legally accountable to the unit holders for the management of the fund. Once you get past that threshold, it's then an entity or a person who establishes, manages, or otherwise operates or winds up the fund. So the second part is disjunctive. So documents going to the establishment of the fund are not necessarily a requirement for the claimant to prove that the defendant was a fund manager. Because, for example, you could well have a fund manager that establishes the fund, who are then replaced by another fund manager who goes on to operate and manage the fund. And in that respect, the fund manager isn't going to have any evidence of it establishing the fund, but it doesn't mean it's not the fund manager. So we say that's actually not relevant. And the last point that I would make, Your Honour, is this formulation should be rejected wholly. I've already said that. I would say there's an inconsistency here as to the way in which the case is being put. And I would say this is akin to a fishing exercise, because on the one hand, you have in both my learned friend skeleton, but also in the evidence of Mr. Al-Ibrahim, and I apologize if I've mispronounced that, and it's paragraph 17 and 18. I don't propose to turn it up, but Your Honour, I'm sure, has read it. The claimants are at kind of, they are willing to go to the extreme of saying it is absolutely clear. They are emphatic in how clear it is from the documents that exist that the claimants were in fact managing the fund. So on the one hand, they say we have all these documents that clearly show you were the fund manager, but on the other hand, they're now coming with a broad request and now seeking to narrow it on the day, saying we need all these other additional documents that actually are going to prove that you were managing the fund. So there's an inconsistency here. And even this proposed reformulation is not necessarily relevant to who is the fund manager. That captures something that a fund manager may do, but it's not definitive. And we say with the additional 5 categories of documents we've provided, and it does include relevant emails and communications for the period that I've identified. It includes the internal policies, it includes the corporate contracts relating to the establishment of funds, it includes the resolutions of the board of directors to the fund relating to the appointment of third-party service providers. Those additional 5 categories are over and above what we had already disclosed, and the claimant has never come back to us in real terms beyond what we have seen to really narrow that down before today. So we say we've given you more than enough. Your own case is that you have enough to prove, and it's clear that we were fund managers. The rest of it is then therefore an unfocused and a fishing exercise in the hope that more stuff comes up to help them prove their case. So for that reason, Your Honour, we would say we would invite you to reject making any order under request number 6, including the reformulation of correspondence between whoever it may be and the service providers.
Thank you. Any more on that, Mr. Biro?
Nothing more on that, unless there's anything I've missed.
Mr. Adair, anything by way of reply? You're on mute, I'm afraid.
Apologies, I switched myself off because my computer was dinging. My learned friend refers to RASMALA management, which he says actually established the fund. Again, we're dealing with smoke and mirrors. RASMALA management, the directors of that company were Eric Swats and another gentleman who were both directors of the defendant. As the directors of the fund are also directors of the defendant, and all management has been carried out within the DIFC. My learned friend helpfully went to my paragraph 51 of my skeleton and said, well, yes, establishment is relevant, establishment of the fund is relevant, but there could have been another fund manager appointed subsequent to the establishment, so it's irrelevant. No one's suggesting that that is the case. What the defendants say is that the directors of the fund, in other words, this has been a self-regulatory fund from the outset, and it's always been managed by the directors. So that's their case. What we say is that the reality of this situation is it's always been managed by the defendant. So establishment is absolutely front and center relevant to whether they are or are not the fund manager in this regard. The date of the incorporation of the fund was the 9th of October 2013. I do not now know off the top of my head the dates of the contracts relating to those service providers, but that will provide the other end of the time limit, the time span. And as far as the points that are made by my learned friend at paragraph, I think it's 22.1 of his skeleton argument, if you can just look at that at page 7 of his skeleton. The assertion is that we've made these constructive suggestions, and they're 5 categories, as he says. So the meetings or the minutes of the meetings of the board of directors of the fund, all those will show, and all they do show, apart from one element that we referred to, is that this fund, they're set out and signed, they're the internal documents of the fund, and they will show inevitably that the fund was being managed by its board of directors. That was set out in the December letter. We received them on the 16th of January. B, this is new, the relevant emails or communications and the reference to search terms for the period the 5th of November 2018 to 4th of April 2019. These are new search terms. I should have just have said that A is also during this period, 5th of November 2018 to 4th of April 2019, which completely excludes the establishment of the fund. B is a new one, and it's the first time, whilst they have said one of their grounds is that it is too onerous and procedurally inefficient, they've never actually addressed this until this application was issued on matters such as search terms and volume. C, again, is all the internal policies. again, limited to that period of time that they contend is relevant. That again is a new proposal which has only emerged since the issuing of this application. D, corporate contracts were suggested in the December letter, but of course suffer from the problem that they are just contracts between the fund and the third-party service providers and show nothing about who actually negotiated them and managed them. And then finally, all resolutions of the board of directors of the fund, again, they're going to show nothing at all about how those resolutions were arrived at. No, they were drafted by the defendant and put before the directors to be signed off, rather like a corporate service provider would deal with them. So those documents do not assist understanding how the fund is managed. They're all limited in terms of their timing to this period from the 5th of November 2018 to 4th of April 2019, which doesn't assist. And the arguments against the reformulation in my submission simply don't work in terms of what we say is what we are now seeking, and what we have formulated with Your Honour is a sensible, it is a limited in terms of time, and it is limited in terms of the documents we seek. And so what I would ask Your Honour to make an order in those terms that we have formulated, albeit during the submissions that we've made.
Thank you. This is an application for a request to produce under the rules 28.16. By rule 28.17, a request to produce is required to contain 1, a description of a requested document sufficient to identify it, or 2, a description in sufficient detail, brackets, including subject matter, of a narrow and specific requested category of documents that are reasonably believed to exist. And then there are other matters as to how the documents are relevant, and a statement of reasons why they're believed to be relevant and material to the outcome of the case and the possession and custody of the party who has them. The relevant request to produce in this case is emails, letters and other documents relating to the nature and scope of IBL's role in the management of the fund and its investments. On its face, that request is plainly not a request to produce in accordance with the DIFC rules. It seems to me that it is not narrow in scope, it's not time limited, it has expressions such as relating to, which are vague, and frankly, from the terms of this description, it would be quite impossible to tell whether or not it had been complied with or not. It is accepted that an important issue in this litigation is whether or not the defendant was a fund manager pursuant to the relevant statutory provisions. It's also accepted in principle that documents which do fall within the proper scope of 28.16 and 28.17 could be possible of being produced. The responses to the objections include at the penultimate paragraph of page 270 of the court bundle the fact that the fund appointed Maples Corporate Services Limited, Maples and Corba Dubai LLP, Apex Fund Services, Dar Al Sharia and PwC for the provision of services to the fund. Those agreements have, as I understand it, been produced, and those agreements, as I understand it, are likely to date back to at or close to the formation of this fund back in 2013 or 2014. Had there been a request for production, time limited, of documents relating to the formation of those agreements, I would have been likely to have granted it, but that is not the request before me. It's also the case that there is no precise formulation of a narrow and requested source of documents. And when I raised with Mr. Beru for the defendant the possibility of providing such documents, he said, not unreasonably, that he would have to take instructions in relation to the matter, that it could involve some difficulties as to what was available, and so forth. In the circumstances, I'm not going to make any order in relation to request 6. It seems to me that it is and always was invalid on its face. And if there was going to be a reformulation, it should have taken place substantially before the hearing of this application. That said, it is still open to the claimant to make a request. If it does so, it has absolutely got to be narrow and specific, and it has got to make sure that it complies with the relevant provisions of the rules. And it seems to me that in principle, if the correspondence surrounding the appointment of these service providers can be identified specifically within a narrow period, it's unlikely to be very onerous to produce it. But I'm not going to make an order now, and if there is a dispute about the matter, I will deal with it in due course. It may well be that at that point the claimant will have difficulties if it doesn't get on with formulating the matter, because although, as I said, I'm not impressed by the suggestion of lateness generally in relation to the making of the request, it does seem to me that this request should have been reformulated a very long time ago. So for the purposes of today, I refuse request 6. Can we go on, please, to request 7? The request 7 is emails, communications and reports circulating internally within RIBL and passing between RIBL and the fund between 1st January and 30th of April in relation to the losses suffered by the fund, the loss-making transactions, the risk mitigation measures used in respect to the loss-making transactions, the cause of the losses, and lessons learned from the losses. Just to tell you my provisional views in relation to this, Mr. Adair, this, it seems to me, is less bad than 6. But it's still pretty broad, and it also seems to me that at the moment you don't need to address me. I'll hear from Mr. Beru in relation to the relevance of the admission in relation to risk mitigation matters. But what I'm concerned about is, again, actually what documents you're going to get, particularly in the light of the material which has been produced suggesting that complying with this request is going to be far from straightforward. And again, it seems to me that I'm not sure you necessarily need the sort of granular detail that it's possible you're asking for. So with that by way of introduction, request 7.
Yes, Your Honour, I think the issue here is, we say emails, communications and reports. Now, this fund has lost $100 million and effectively collapsed. It was suspended in 2021 or 2020 and has never been unsuspended. It now seems to be undertaking other activities, and Your Honour will have seen from my skeleton arguments, and perhaps seen in the bundles as well, a winding up petition that's been presented on the just and equitable ground in the Cayman Islands, referring to a lack of transparency in relation to what has gone on in the fund. Now, putting it plainly, if a fund run by professional financial services providers loses 100 million and collapses, one would expect a report to be produced looking at the lessons learned and why this happened and what the causes were and what mistakes were made. Now, when we put in this formulation the word report, it was in anticipation that some form of report would have been carried out. But emails and communications covers the possibility that actually it wasn't a formal written report, but was something that was set out in an email or something regarding. But there must have been some proper analysis of where it all went wrong. Now, if we could go to page 271 of which is the schedule.
Yeah.
So on page 271, we see that actual formulation of the request, and it has that time delineation in there, 1st of January to the 30th of April, and it's specifically to the reports circulating internally regarding or in relation to the losses suffered by the fund, the loss-making transactions, the risk mitigation measures. It's effectively what it's going to is what caused us to lose this enormous amount of money. The objections that were made to it are, in my submission, not proper objections. Now, Your Honour says you don't need to be addressed regarding the relevancy point and the pleading point. I address you only to say that that has now been abandoned. It doesn't appear in the witness statement that is made, and nor does it appear in my learned friend's skeleton argument. So that was very quickly abandoned. We're left with the suggestion that it is an unreasonable burden and inefficient and disproportionate. And
well,
in support,
just in relation to that, I mean,
yeah.
the point which is made is that in relation to one of these transactions where they've done a search, they've ended up with 23,152 they've ended up with 2,510, and across 12 counterparties, they've got 23,152 documents.
Yes. In the original objections, there was no reference at all to, or no particularization of this allegedly burdensome or unreasonable burden that might be placed upon them. Now, what I would submit is this fund is presently in the process of trying to recover its losses by means of litigation, it would appear, in various parts of the world. If it has lost 100 million and it has analysed that, my submission is that it is unrealistic and obtuse to say we're going to have to carry out an electronic search of various different servers, etc., to try and see if we've got any documents that looks into the reasons why we might have lost 100 million. If you have lost 100 million as a fund and you haven't actually written a report, or if you have written a report, you'll know where it is, because this is going to be a touchstone for all future conduct. We can't lose another fund in the way that we've lost this fund. So the suggestion in my submission that they're going to have to carry out an electronic search using search terms, throwing up 2,500 or however many documents that are going to have to be manually reviewed in order to see whether or not they have internally analysed what went wrong and the lessons learned, in my submission is misleading and disingenuous. They must be able much more simply to identify whether or not they've looked into this issue and they've looked internally into the causes of the losses that they've suffered. And that's the approach that we've taken throughout this. They, of course, have only addressed the search issue in their most recent witness statement during the course of January, after this application was issued. They never said anything about this before. They never particularized their difficulties before. But what we would say is this is misleading. If there is a report or an analysis of what caused the losses and the lessons learned, and incidentally, one gets and one understands that this is a slightly obtuse and smoke and mirrors, because if one looks at the end of the objections, it says the wording "lessons learned from losses" is also unduly vague. Now, in my submission, in any commercial disaster or any civic disaster, the phrase "lessons learned" is commonly used and is understood by any English-speaking person as to exactly what it means. So,
Mr. Dad, you're saying effectively there must exist a report which sets out what the lessons learned were and how we lost 100 million. The consequence of making a document production order is that within the time ordered by the court, the party to whom the request to produce is addressed shall carry out a reasonable search for the documents' possession, custody, or control, as to which no objection is made. Now, are you saying that they are not required to carry out an electronic search?
I'm not saying they're not required. I mean, if they are honestly saying we have no...
Let's, I mean, there's Taylor Westing on one side and Simmons on the other. They've carried out this search. There are 23,000 documents. You're claiming that you don't want to have tons of documents landed on you. How do you say they go about finding out whether they've got this other than by an electronic search?
Well, I mean, the point that I make initially is that if you have carried out a report, if you have lost 100 million, you will have analysed why you lost 100 million. And if you have done that exercise, then you will know where it is. And the suggestion that they have to carry out an electronic search to identify it, they may well have put in these search terms and they've thrown up all these documents. But in my submission, they must know where it is. That it cannot be otherwise. But if they're saying they don't, this is such an important issue because it goes to the heart of it. They say it was all due to COVID. I mean, it doesn't quite stack up because they accept that losses were suffered in relation to the Met Trade transaction and the Farlin transactions, which were both undertaken in 2018, and the losses would have crystallized or would be crystallizing by then and had nothing to do with COVID. But apart from that, they say this is all down to COVID, and that must be in a document. We say no, inadequate risk mitigation measures, which is borne out a little bit, the view taken by the petitioners in the Cayman Islands winding up petition. They tend to take the same view, and that there should be an explanation for this. So if they have to carry out these searches, this is such a central issue that they'll have to carry out those searches. But in my submission, it's very unlikely that they couldn't, because Mr. Swats, Mr. Bitcon, who are going to be giving evidence at trial, who have been central to the management of these investments and this fund, because Mr. Swats is double-hatted. He's a director of the defendant. He's also a director of the fund, and he's also a director as RASMALA management. So he's omnipresent in all of this. He must understand very specifically why the losses have been sustained and whether or not any report has been carried out. So,
well, one possibility would be to say in response to request 7 that the request is for reports circulating either internally within RBL or passing between RBL and the fund between the 1st of January 2020 and the 30th of April 2021 in relation to the losses suffered by the fund and the causes thereof, of which the 2 identified gentlemen are aware.
Yeah, that would be a way of narrowing it down in a manner.
And if they say they're not aware of any, well, no doubt you're cross-examining a trial.
Yes.
But I mean, sorry, I'm sounding like a broken record, but it does come about because, frankly, whoever formulated these requests was so anxious to cover all the bases that they've used very broad terms, which frankly are not appropriate for what should be a targeted request.
You're right. I accept that criticism, but in my submission, one should adopt a slightly more purposive approach, particularly to this particular request, it uses the word reports. It covers other types of document because one could never be sure exactly what form a report will take. But essentially, what it is saying, we need a report. There must have been a report carried out between specified dates relating to the losses caused and the lessons learned from those losses to ensure that it won't happen again. Please disclose that. And that in my submission is not excessively broad. It's not confusing, and it should be fairly easy to produce. Now, if this had been done earlier, a search, etc., throwing up those documents, there would have been sufficient time for them to be properly reviewed and a smaller amount of documents actually provided to us. Because of the delay that has happened, this has not happened. But in attempting to ensure that the court has before it the documents that it needs in order to resolve this issue, my submission would be that the formulation, the slight reformulation, and my submission is it's not a reformulation in the way that Your Honour was considering for request 6 and rejected. It is merely just clarifying it so that there will be some comeback, if you like, and there can be some cross-examination into it for the purpose of the trial. But my submission is that would be the way to proceed, and that would be an acceptable way to proceed. And if these gentlemen say we have no idea, we've never ever thought about why the losses might have occurred, and certainly never committed anything to paper about it, well, okay, we'll have to deal with that, and whether it is credible during cross-examination.
Yes, Mr. Berry. You're on mute.
Apologies. Thank you, Your Honour. Just in respect of the first point, briefly, about the relevancy of this, I don't take any issue with the potential relevancy of this issue. At the time that we objected to it, the claim as it was pleaded was slightly different. It was subsequently amended to include the specific representation about the fund's risk being adequately covered at all stages by risk mitigation measures. So as it went on and as we corresponded on it, we no longer objected on the relevancy, hence why we made proposals to the claimant as to what we believed could be captured by this. But we never had anything back until this right now as to a proposed reformulation of it. And that's been the running theme in respect of all of it. It's been an entrenched position we're not going to shift from September until February. And then now it's all being reformulated. And of course, I'm not able to take instructions on the fly here in respect of whether any of this is workable or unworkable or what it looks like. So we're put at a disadvantage in that sense. And the court should focus based on what the application is, which is the formulation on 7. And what I do say in respect of that formulation is that there are 3 principal reasons why that should be rejected. Now, just before I get into that, there are, and I'm sure it's not done deliberately, or I'm sure it's not intended this way by my learned friend, but there are, in fact, at least implicit allegations that either Simmons or my clients have been insincere or they're seeking to be misleading or whatever. That's not the case.
I'm not going to be deciding this application on the basis of any alleged insincerity in relation to that. I'm interested in seeking to ensure, insofar as the court properly can, that documents which are properly requested in accordance with the orders which have been made are provided in order that there can be a fair determination of the trial on the 10th of March. And for what it's worth, I didn't understand Mr. Adair to be suggesting when I pressed him that there was any insincerity in relation to this. So you don't need to trouble me on that.
I'm grateful, Your Honour. So the three principal reasons I want to go into. The first one, again, which Your Honour has observed and we would agree with, so I'm not going to push it too forcefully, is that the request is just overly broad as it's currently framed. Emails, communications and reports can capture any range of any number of documents. And Your Honour has seen in the witness statements that, and this is what we did back in January, so the claimant has had time to come back to us in respect of it, and they haven't. The reply evidence didn't even touch upon it. But that's a very broad category, and the subject matter is also very broad. If we break it down, they're asking for reports or emails or communications on the losses suffered, the loss-making transactions themselves, the risk mitigations used in respect of that, lessons learned. Now, my learned friend criticized us for saying, well, lessons learned is an obvious phrase. But actually, if you go back to look at their reply to the objections, that was one of the only things they had said they'd be willing to compromise on, to remove that phrase. But they haven't done, but they did say they would be willing to. So we say it is incredibly broad. And at paragraph 28, one of my skeleton, which reflects what was said in Mr. Beheshti's statement back in January, we are looking at in the region of 20,000 plus documents if we have to perform these searches and then go through them to identify this. But the second reason that I say this order should be rejected, and this is important, is because we have already provided what we would say are reasonable and proportionate documents in response to this. And we've been proactive in doing that, as opposed to the claimant trying to reformulate and help us do that. And Your Honour, if I can just first of all take you to Mr. Beheshti's statement about the actual losses and how these were discussed, because Mr. Adair says, well, there must have been these reports, all these losses, there must have been, it must have been the case. I don't quite know the basis on which he's making that assumptions. I can understand that there may be, but in certain circumstances, particularly in COVID when everyone's panicking, there may not be. But Mr. Beheshti deals with this at paragraph 25. If I can ask Your Honour to go to page...
Sorry, can you go to... Sorry, you'll go the page reference, yeah.
It is. It's page 483. It's in section... Section E, document 5, page 483.
Yeah.
We can see paragraph 25 below. The provisions of these documents is reasonable to satisfy document request 7. This, and I'll come on to that, Your Honour. It's about what we've agreed to provide.
Yeah.
I understand that internal discussions within RIBL relating to the valuation of certain transactions, including any defaults or delayed payments, would be discussed orally at the valuation committee meetings, which typically took place monthly until COVID and periodically thereafter. And no minutes were taken of those meetings, nor were discussions detailed in any email. So Mr. Beheshti set out the position of exactly how the fund was dealing with and responding to the losses that were incurring on these transactions, which is through this valuation committee. And what we have agreed to provide within the date range that has been set out in request 7 are all of the documents that were used by this valuation committee of the defendant, which was the committee that the defendant established to assess and determination valuation matters affecting the fund, which includes the loss-making transactions.
So sorry, I just want to be clear about you've provided all of the documents which went to this valuation committee. Is that what you said?
Yes. Yes. If you see above paragraph 24, Mr. Beheshti's, you can see the summary of what the defendants had agreed to provide you.
Yes. So documents used by means everything which was sent to the valuation committee.
I haven't. I need to check what those documents are. My understanding is it's effectively there's a spreadsheet which is created by this committee, which is then updated, and then there are meetings that are had in respect of whatever's on there. I don't understand there at least to be anything else that's gone back and forth, at least in terms of what we produce. I don't understand.
Well, you've shown me what the evidence is, so I've seen what the evidence is. Yeah, that's your second reason.
That's the second reason, and just so your Honour is aware, that's about 118 documents or so that we've provided in respect of these 3 categories. Yeah. And we say all of them are likely to go to the losses that are suffered. Now, the board minutes themselves, Your Honour, I don't know if it'd be helpful for me to take you to it, but for what it's worth, the board minutes do show the discussions that were going on and comments on, for example, the litigation and negotiations arising out of the defaults of counterparties such as Metro and Fund.
I'm not going to stop you taking me to the board minutes. I mean, what I'm actually, I think, concerned on this is Mr. Adair, when one strips it back, is saying where a fund loses this much money, and brackets, he may say, regardless of whether it's COVID or not, you would expect there to be one, possibly more than one, report which identifies what the losses were, what the causes of them were, and what the lessons learned were. Now, if those reports don't exist, they don't exist.
Yes.
And I'm, as I indicated, not particularly sympathetic to a sort of trawl. It also seems to me Mr. Adair says, well, if they exist, they must know where they are. Well, that really is implicit within that is that the main actors on your client's behalf will know if such reports existed and know where they're to be found. Hence my suggestion of saying, well, a reasonable and proportionate search, which it seems to me one could order, limit to this, is limited to asking your two main witnesses before they get to give evidence either in person or remotely. Are you aware of a report or reports which identifies the causes of these losses and any lessons learned? If so, we're required to produce it, and we've got to produce it. If not, we're not required to go searching through 23,000 documents. Now, at the moment, I'm quite attracted by making that order, because it seems to me what we do not want to have happen is Mr. Adair to be cross-examining your witnesses, say, well, you know, there's no report, etc., and one of your witnesses says, well, there is a report,
Yes.
and so forth. That would be unfortunate. Yes. So at the moment, and I understood Mr. Adair to be limited to himself, I think you can confine yourself to dealing with an order which is limited, as I sought to formulate, reports of which your two principal witnesses are actually aware within the relevant period, dealing with the losses or the causes of the losses.
Yes, Your Honour. I do see the sensibility in an order of that kind, and we are. If the order was limited in that sense, it's hard to resist, because it's all we would be doing is effectively confirming with our witnesses whether they're aware, and if they are, we can produce the reports that they identify, and if they're not, then that's the position. As I understood it, I don't seek to preempt what they may say, but as I understood it, paragraph 25 of Mr. Beheshti's statement sets out that actually these were largely dealt with in meetings that were not minuted.
It may be that Mr. Beheshti has already covered this. Yes. I don't read paragraph 25 as precluding the existence of such reports. But anyway,
sure. But Your Honour, I'd be if the order was limited in that sense, then we would be content with that, and we can make the inquiries with our two witnesses.
Yeah. Anything more you want to say in relation to this?
No, Your Honour. I think if that's the position we've landed on, then I have nothing further to say.
Mr. Adair, you've got a right to reply. I am presently minded to make an order of the sort that I have identified, but limited to documents of which the two witnesses of the defendants are aware during the relevant period. If you can't agree with the precise formulation, I'll impose it, but I hope it's clear what it is that I'm looking to achieve. Do you want to say anything more in relation to
that? Your Honour, I don't think in those circumstances much constructive would constructively be achieved by me responding to some of the things that my learned friend had said. If Your Honour is minded to make an order in those terms, then that will be acceptable to us. As you say, we should be able to formulate that. But going just with that in mind, it might be worth just looking at the original formulation and seeing how we might just tweak that so that at least it's been aired during the course of this hearing. So going back to page 271. Yeah. We refer that it starts as emails, communications, and reports. Now, I think obviously what your honour is focusing on, and what I focus on in my submissions, is the word reports. The other two were really covering the format of the way in which the report might have been undertaken. And so, but if it's understood that it is a report, whether it had been set out in an email or whatever, that's fine. And I think the caveat that is within the knowledge of Mr. Bitcon or Mr. Swats, I think if that is then read into it, I think then we get a satisfactory formulation. Essentially, our case is that the causes of the losses is a lack of risk mitigation measures. The defendant's case is that it was all down to COVID-19, and what we want is a report regarding the causes of the losses, and the lessons learned as a result of those losses.
Okay. Sorry, anything more?
Well, I was going to say, all the documents that my learned friend has referred that they're prepared to produce deal with the quantum of the losses, not with the causes of the losses.
Yeah, all right. Sorry, anything more? Otherwise, I can just go to rule briefly on this.
Nothing more, mate. Your Honour, no.
Request 7 is for emails, communications, reports circulating internally with RIBL and passing between RIBL and the fund between the 1st of January 2020 and the 30th of April 2021 in relation to the losses suffered by the fund, the loss-making transactions, the risk mitigation measures used in respect to the loss-making transactions, the cause of the losses, and lessons learned from losses. This request is more narrow and focused than that which I criticised in relation to request 6. It is, however, still very broad, partly because of the way that the alternative formulations are put forward. Mr. Adair has made it plain that what he is really looking for is documents in the nature of reports circulating within RBL and passing between RBL and the fund between those dates, which identify the causes of the losses, subject to precise formulation by the parties and subject to an important qualification, which I'm going to come on to. I'm prepared to grant that request. I'm not going to grant it, however, generally subject to a search. I'm going to identify that the court is satisfied that a reasonable and proportionate search for these purposes is limited to verifying with the two witnesses for the claimant, Mr. Bitcoin, and I'm afraid I've forgotten the other gentleman's
Mr.
names, Mr. Choksi, as to whether they are aware of the existence of any such report. If they are, it must be produced. If not, then a reasonable and proportionate search will have been carried out. I will leave counsel to agree the precise formulation of that order. If there's a problem about it, I will settle it myself. But that's the order in relation to request 7. Request 8.
I'm grateful, Your Honour. So request 8 is formulated at page 273 of the bundle. Again, but going back to the schedule, there's been transaction.
I'm sorry. I'm going to give you. I'm going to give you a preliminary review about this because I think it'll help you. You say several times in your skeleton that the court is going to have to determine the causes of, I think, each of the losses which has been suffered by the fund. Now, I will decide whether I do need to do that when I've heard rather more about this case than I presently do. But I'm very far from satisfied that at the moment for document production, that level of granularity is required. Broadly speaking, it seems to me that your case in relation to the causes of the losses is that this fund was really pretty careless in relation to what you refer to as risk mitigation matters, and didn't take fairly basic precautions to satisfy the integrity of the fund. Mr. Berry's case is that the substantial problem was COVID. And I have some difficulty in seeing that documents of this sort, which go down to a very granular level and are going to potentially involve the production of really quite large numbers of documents, is necessary or justified. So that's the hurdle you need to overcome in relation to request number 8.
I'm grateful, Your Honour. I think the position on the pleaded cases, as far as this is concerned, is that there were representations made, oral representations, and indeed some written representations, which were to the effect that all the risk mitigation measures identified in various documents were used in respect of all the transactions that were undertaken, point one. Or alternatively, what the defendants say is adequate risk mitigation measures were used in respect of every transaction that was undertaken. So what that means is that we are going to have to look at those issues, and in particular it is whether there were adequate risk mitigation measures were used in relation to each loss-making transaction, because that's going to be the litmus test, excuse me, regarding whether the cause of the losses suffered on that transaction and generally was a failure to use adequate risk mitigation measures. And if that is the case, then there will have been misrepresentations made. We say, I mean, my learned friends' clients dispute that some of the representations were ever made orally, so there is an issue there. But assuming that they were made, there will be a question as to whether those representations were false or not. So we have this issue really in relation to every loss-making transaction as to whether the losses suffered were COVID or inadequate risk mitigation measures. And that's why I made the statements that Your Honour referred to earlier in my skeleton argument, because if the difference between this particular request and the previous request, request 7, is that is focusing on whether there was some analysis by the fund, by Ribble, as to what the causes of the losses were more generally. But in terms of establishing whether the losses and to what extent the losses were suffered as a result of, shall we say, the failure to adequately mitigate loss in respect of each transaction, indicates in my submission that one was going to have to look at what risk mitigation measures were actually used in relation to each of the transactions that resulted in losses.
I mean, as I understand it, there have been 12 counterparties to whom the fund was exposed and in relation to which losses were suffered, and those have been identified and documents have been produced in relation to those 12 counterparties. As I understand it, and I'm taking this from Mr. Beheshti's evidence, you've also got, in relation to those, the transaction documents which were set up, and as I understand it, those include the security documents which were entered into. Now, if you've got those and you know what those agreements were, what the security documents were, why do you need more in relation to this?
But that may actually ultimately give us all the answers we want. There is a slight caveat on that, because for instance, what emerges, and I think we will, I refer to the winding up petition in my skeleton argument, and I think it's paragraph 63 of that, refers to a presentation given to the petitioner in that by the fund in relation to its attempts to recover monies. And in particular, there is litigation in the Delhi High Court against a gentleman by the name of Mr. Gupta, who had provided a personal guarantee. And what they say, the petitioner says, is, why was the only risk mitigation measure a personal guarantee from Mr. Gupta for this very substantial lending?
Well, that was prompting me to make the point. I mean, you make that point in your skeleton, and it may or may not be a good one, but you can already make it. I mean, you don't need any further documents to make that point.
Well, what we're saying is that if you are limiting your risk mitigation measures to a personal guarantee, then there must have been some, if they were behaving adequately and taking adequate risk mitigation measures, and they say that's adequate, then there must have been some sort of credit report on Mr. Gupta in those circumstances to say, yes, he's good for this $20 million, etc. There's no problem there. And so it was really saying, well, actually, just giving these documents is not really sufficient. Now, we've had these documents disclosed in waves. We first got just the facility agreements, and they said those are entirely adequate for your purposes. And those made vague references to security documents, but didn't actually indicate, and we explained this in correspondence, didn't actually indicate whether that security had actually been taken. And we had various other facilities which were renewed or increased, and it did not state whether the security had been enhanced in any way to accommodate the the increased sums that were being advanced. And we had issues with where some sort of assignment of goods was taken in order to secure the lending. And it was, shall we say, agricultural produce, which was obviously going to deteriorate and rot. When the facility was renewed, would not the goods over which the security had originally been taken, were they still in existence? Were they replaced with something? And those were the issues. Now, we first got, and so we said we need more than that. We need the security things. Now, these security documents were not provided prior to us actually issuing this application. These have been provided more recently, and I think it's important to understand. On Wednesday night, I think the documents that were provided then are largely documents relating to the transactions. They're transaction documents, and they've now condescending to the sort of detail that we said was necessary. But only after we've actually issued this application. And so what, if we go to what Mr. Beheshti actually says in relation to request 8, he says...
Page 484.
Yes, I've got 484, and he's talks at page 20, paragraph 26, about what he says. Document request 8 essentially comprises a request for both transaction documents as well as documents constituting and giving effect to the risk mitigation measures employed by the fund. He then goes on to say, much of paragraph 40 to 42 witness statement therefore labours under misapprehension. In fact, the true position is that the claimant has already received, or with respect to documents that have not yet been disclosed, will imminently receive all facility agreements with its obligers, etc., and the security documents used in respect of the loss-making transactions. Now, these are effectively documents here, because one has to then go back and look at what was actually being promised in terms of the letter that was written on the 11th of December.
Mr. Adair, I am conscious we've still got the request to deal with.
Yes,
at the moment, it seems to me you're telling me that these documents have been provided after you issued your request for document production. Well, fine, that may in due course go to other matters, but it rather goes against the proposition that you need anything more than that which is you've either got or well, I think I'll confirm with Mr. Berry in a minute, but I think you've now got everything which has been promised by Mr. Beheshti, even if some of it may have only been produced on earlier on this week.
But I think the point I'm just making is at page 568, which is the last letter they wrote before we issued the application.
Yeah,
it refers at page 2.7 to the fact that they would provide facility agreements and other transactional documents, or they have already provided facility agreements and transactional documents. And then they say our client has shortlisted the transactions relate to this request, and effectively and say that they will disclose the security documents for this transaction. But there's no details there. There's no addressing of the points that we've made. Once we issue the application, then all of a sudden they start pouring out documents and promising to provide this, that, and the other. That's happened now. It may well be that the documents, the 2,000 documents that they provided on Wednesday night, actually will provide sufficient information to satisfy request 8. If that is the case, and we are in the process of going through them, and they all seem to relate to transaction transaction documents or documents related to the transaction, and they actually go beyond what is referred to in that letter dated the 11th of December. If that's right, then it really just shows that this application was properly issued and needed to be issued in order to obtain these documents. And so it's rather like, you know, if you issue an application for certain information to be provided or certain documents to be provided, and after that application is issued, the respondent does it precisely what you're asking them to do, then it just shows that the application was well made. It may not be necessary to make any further orders because they have done what they needed to do. But obviously, there's no suggestion that the application ought to be dismissed or was wrong. It's been satisfied by what has happened. I can't completely evaluate the 2,000 documents that have been sent on Wednesday night, but if they do provide all that information that we requested and enable us to see precisely what risk mitigation measures and what steps were taken to mitigate risk on each of those transactions, then that is what we're after, and that's fine.
Mr. Berry.
Your Honour, I can take this briefly because it seems to be two things. One, Your Honour's not minded to make the order that's requested, and two, Mr. Adair seems to be at least implicitly accepting that he may have all he needs. The only point I just want to touch upon briefly, because at least my understanding of the situation, it might be setting it up for some kind of costs argument, but the paragraph that Mr. Adair had just taken you to does confirm on the 11th of December, that is before the application was issued, that all of the facility agreements had been provided to the counterparties. And there was an offer in that letter to provide the security documents which form part of the transaction documents. So the offer was made prior to the application being issued, and there was no willingness to engage with that or to reformulate or to drop this request, including at the point at which the application was made and the reply evidence was filed. So as things stand, the facility agreements have been provided, the security documents for the loss-making transactions have been provided, and some further transactional documents. Now, the one thing that's worth bearing in mind, which is why we say this application and this request was not well formulated and has not been properly brought, is the documents that are actually being sought, which are not, they don't mirror the formulation in terms of credit reports and the such. These are all due diligence documents. They're not transaction documents, which is what is actually identified in the formulation of request number 8. So we have made the offer and we provided both the facilities agreements prior to December, and we provided the security agreements as far back as a month ago in January. So they've had them for some time, and they've nonetheless pursued this request, which is now not going to be made.
Can you just tell me what were the documents which were provided earlier on this week? I mean, in broad terms, obviously.
I don't. I need to take instructions on that. Well, what I do know is that the security documents
Were provided in January.
Were provided in January, and some further transactional documents, Your Honour, were provided this week. So the way it works is there's a main folder which has the counterparty. Within that is a subfolder which are financial transaction documents. Those are what we consider the agreements, the security agreements and so forth. They have been provided in January. And whatever else was there by way of final execution that doesn't form a security agreement or the facility agreement, we've provided those as well, and that was provided this week. And we say that goes beyond actually what would have been necessary, but we were willing to provide them anyway.
Right. Okay. Mr. Adair, anything by reply?
Yes, I think the answer to that point arises if Your Honour goes to page 572, which is Taylor Wessing's letter dated the 20th of December, responding to the letter we looked at. And it's actually paragraphs 10 to 12 that are relevant. They're very short. Paragraph 10 says, referring back to the paragraphs we just looked at, we note your agreement to provide the security documents for transactions involving non-performing assets of the fund as identified by the fund's auditor KPMG. That satisfies ALAWWAL's request at paragraph 36.1 of the 11th of November letter, but is unlikely to address the issues of whether the risk mitigation measures were employed in respect of each of the loss-making transactions to which ALAWWAL was exposed by its investment fund. Therefore, ALAWWAL therefore requires production of the remaining documents requested at paragraph 36.2 to 6 of the 11th of November letter. Now, if Your Honour goes back then to page 550, and one sees what those documents are, or that were requested in those paragraphs.
Mr. Adair, we have got a hard stop here, and you're replying.
Right.
We've got 2 hours for this, and we've still got to deal with your request for further information.
I'm going to be just 2 more minutes. If you could go to 550, you'll see that those are copies of credit reports of personal net worth statements, property assessment reports produced in respect of requests of proposed amendments to facilities, and the minutes of meetings. The documents that were provided the Wednesday night are much more detailed and are actually condescending down to the more detailed sales contracts, notices of assignment, board minutes, RTFF board minutes, 1st of August 2018 with apex comments, other board minutes. So what they've actually done is they've now satisfied those 36.2 to 36.6 requirements subsequently. So it's not a case of them only having provided what they promised to provide. They've provided what we also additionally responded to in our letter on the 20th of December. And that is a consequence of the issuing of this application.
This is an application for the transaction documents relating to each of the loss-making transactions undertaken by the fund to which ALAWWAL was exposed by virtue of its investments in the fund, including the documents constituting or giving effect to the risk mitigation measures employed in respect of each of these loss-making transactions. As formulated, this request suffers from the defects which I've already identified of being overbroad, insufficiently precise. In fact, it appears to me that a considerable volume of documents, including, as far as I can see, the documents which have been requested and then reformulated by the claimant, have been provided, and in the circumstances, I'm not going to make any order in relation to request number 8. It also seems to me more generally that although unquestionably the cause of the losses is important, I'm far from satisfied that one needs to consider the cause of each and every loss on a very granular basis. I say that to make clear that I shall require some persuasion if that is in fact going to be the claimant's position. But anyway, for present purposes, I'm not prepared to make any further order in relation to request number 8. It seems to me that considerable documents have been provided, and I'm not satisfied that there is anything which is properly the subject of request 8 which hasn't been provided. So request 8 is refused. Right, I want to go on to deal with the request for further information. Mr. Adair, if we look at your skeleton argument and identify the points which you want, you first of all say that you want the following information: whether the fund is an external fund or a foreign fund, by whom the fund is managed, whether the management of the fund takes place within the DIFC, and if so, pursuant to what license, and the basis upon which the defendant has received monies from investors in the fund. Now, dealing with this, as the relevant provisions are Part 19, and in particular the DIFC 19.6 requires the request should be concise and strictly confined to matters which are reasonably necessary and proportionate to enable the first party to prepare his own case or to understand the case he has to meet. Now, it seems to me that on the pleadings, and certainly on the basis of Mr. Beru's skeleton argument, Mr. Beru's case is that this is not an external fund, and he is not the fund manager, and the management of the fund was carried out by the directors. That's as I understand what he's saying. By whom the fund is managed is the directors. C and D seem to me to be in the nature of what used to be called interrogatories, rather than requests for information. And I can't at the moment see why you need the answers to, well, actually any of them, but particularly C and D, in order to comply with 19.6. So you've got an uphill battle in relation to an order in relation to this.
Well, Your Honour has referred to 19.6. I think we should also, just to complete the trawl of the rules, refer to 19.5, which requires us to set out the request in writing prior to making any application, which we did, and I refer in my skeleton argument, I won't take you there, to 2 letters. One letter which we sent on the 11th of November.
I'm not suggesting you haven't set this up properly, but
yeah.
But you've still got to comply with 19.6.
And then they have to comply with 19.19.1, which requires them to actually respond one way or the other. And if they object to, so 19.19, I think there was a typo in my skeleton. I think it said 19.9, but 19.19.1 says that if they receive a written request, the party in receipt must inform the party seeking clarification or information promptly in any event within that time, may do so in a letter or a separate document. And if you go on down to 19.26, where they haven't replied, then effectively the court will make the order on the papers. Now, we've never had any response to this, so no response saying we object to providing this, or this isn't appropriate. The letters just completely ignored this point. So we got, after we'd made the first request, there was a letter on the 11th of December, completely ignored it. So we asked it again and made clear that it was a request under Part 19. That is the background.
Why do you say you need this information?
But what we say is, if the defendant's an authorised firm, there must be complete clarity about the nature and regulatory status of this fund. Now, it said it's not an external external fund. And all we've asked them to do is to pin their colours to the mast and say, are they then saying that it is a foreign fund? Just advance a positive case. They ignored that request. Now, I don't see why they would just not say, yes, well, we say it is a foreign fund. The basis upon which they denied that it is an external fund seems to be they say they're not the fund manager. We've just asked them to say, well, one, who you say is managing, and I accept what Your Honour says, that it's pretty clear from their defence that they say that it's managed by the directors. We asked them to say where it is being managed. Now, they've accepted that there's no physical presence at all in the Cayman Islands, but we want to be absolutely clear where it is being managed. Is it being managed?
Just pause there. I mean, let's be realistic about this. You've got a positive case that this is being managed in the DIFC. They haven't got a positive case that it's being managed somewhere else, unless I've overlooked it, which is more than possible at this stage. But in the absence of such a positive case, that's the position.
Yeah.
Why do you need this information?
Because it is important when there is a regulated firm that they are absolutely transparent regarding how.
We're not talking about regulatory obligations. We're talking about what is required for the fair trial of this action starting on the 10th of March. We're not talking about the obligations of regulated entities to be clear and so forth. That seems to me is irrelevant to this question.
Well, my submission is that my clients invested in this fund on the basis that it was properly regulated. They've entitled, when we go to court on this trial, to understand exactly what the regulatory status was. But if as Your Honour is indicating, you don't consider that it's necessary for them to be clear about this, and to be frank, this is not an onerous request for further information. It was a series of short points that could have been answered in one paragraph in the letter they sent to us on the 11th of December. But if they failed and completely ignored the request when it was written in not one but two letters, they cannot then complain when we actually make that application to the court, as we were going to be here at the PTR in any event. So if they failed to comply with 19.191, ignored the request not once but twice, then what were we to do but issue this application? If they were objecting to it on the grounds that it was an improper interrogatory or something like that, then they should have said that in their letter on the 11th of December, or subsequently they should have come back after the 20th of December, don't issue this application. We say that it is an improper application in some way, shape or form. But we've had nothing about that. So it was perfectly proper for us, when being ignored in correspondence and being ignored constituting a breach of the rules of this court, to actually issue the application. So if you're not with me that they should answer these questions, and my submission would be under 1926. If we actually submitted it to the court would probably have made the order on the papers alone by virtue of the refusal. But if you're not with me on that, then in my submission, it's not a case where the application should be dismissed or there should be any cost consequences, because they have failed to respond in writing.
Yes. Anything you want to say on this, Mr. Berry?
I do, Your Honour, but I'll endeavour to be as quickly as possible. The first point is, whilst we did not respond to the request as it was first made, because quite frankly, it's not a request under Part 19. Your Honour's quite rightly pointed out that the rules under Part 19, but 19.7 says that requests must be made as far as possible in a single comprehensive document and not piecemeal. And then 19.8, a request may be made by letter if the text of the request is brief and the reply is likely to be brief, otherwise the request should be made in a separate document. And then 19.9, if a request is made in a letter, the letter should, in order to distinguish it from any other that might routinely be written in the course of the case, state it contains a request under Part 19, deals with no matters other than the request. The first letter they sent, it just says it's headed regulatory issues and proceeds to ask a bunch of questions that quite frankly are not relevant or have already been answered. And when we came to respond the second time, in our letter of the 11th of December, we did say that this was duplicative and we're not required to answer it. So we told them no. But Your Honour's observation is completely right, which is the claimant criticises us for not having advanced any positive case about the regulatory status and so forth. And we say that criticism is misconceived. We're only required to respond to the case the claimant has advanced. And the claimant has alleged that the fund is an external fund and that certain statutory duties are imposed on the defendant. We have denied that for the reasons that are set out in our defence. The claimant has not pleaded that the fund was any other type of fund. So we've responded to the case as pleaded, and it's clear that we deny it's an external fund. It's clear that we say the directors were the ones who were managing it. And as respects of the other two, we don't understand the relevance of it at all. So the application should not have been brought, and it wasn't properly made as a request to begin with. When they sought to rectify those errors, we told them, again, you're not entitled to it. And they pursued with the application nonetheless, which we say is wholly misconceived. So it should be dismissed, Your Honour.
This is an application for further information under. Oh, sorry, Mr. Adair. Anything by way of response?
Well, just very quickly, my learned friend said that they said in their letter of the 11th of December that it wasn't appropriate, but they don't. They make no reference at all to the request. Where they say this is duplicative is in relation to what was then document request 9, and that is paragraph 2.10 at page 569.
Can you give me the reference to the 11th of December letter, please?
Yeah, you'll find the 11th of December letter, the relevant paragraph at page 569 of the bundle. So that's actually where he says this request is duplicative, is relating to claimant's document request 9, which related to subscription offer documents. There's nothing to do with, and I can see no reference to the questions that were asked. We then came back, and if you go to page 5.
Sorry, just on this, if you are relying on something specific, Mr. Berry, I think it'd be helpful just to identify what it is in the 11th.
Well, Your Honour, Mr. Adair's taken you to 210, but if you look at paragraph 2.9 before it on the page before,
yeah,
it does say in respect of this request, your letter now makes a request pursuant to RDC 19 and the following terms, and then it goes on to set it, and then we say it's duplicative.
Okay, that's what you're referring to anyway. Yes, Mr. Adair.
Okay, well, we're looking at that. That's quite confusing because it then sets out the ALAWWAL requires our ability to explain the base on which it contends it was entitled to sign the subscription documents, which is request.
Mr. Adair, I mean, this seems to me at the moment to be going mostly to costs rather than whether or not there's actually a justification for giving the order.
The final point is just on page 572. It was suggested that it wasn't a clear offer; it was made piecemeal, etc., or queer request. 572 sets out just the requests in 4 clear sub-paragraphs, and paragraph 15 says this request should be treated as a request for further information pursuant to RDC Part 19. So that's on page 573, paragraph 15. And that's received no response to, and my submission is that the response that was received in the previous letter was far from clear. We understood it as responding to the document request 9. But I've made all the submissions I can make about why it should be answered. Your Honour gave an indication there. What I am doing is saying it was a properly made request because of the failure to make any response to it, and that is a cost issue. I accept that. Yeah, that's all I have to say.
This is an application for further information pursuant to Part 19 of the rules. Part 19.1 is in quite wide terms, but as the court has made plain previously, it is subject to 19.6, which requires the request should be concise and strictly confined to matters which are reasonably necessary and proportionate to enable the first party to prepare his own case or to understand the case he has to meet. Having looked at the 4 requests, it seems to me that none of those fulfill the relevant criteria, and Mr. Adair hasn't really sought to explain why they do. His point is, or his client's point is, that a regulated body should be clear and transparent about what its case is and what the obligations are. That may or may not be the case, but it seems to me that for the purposes of the trial, it is plain what the case is. And in those circumstances, I decline to make the request which is sought. So the request is refused. That deals with those matters. The costs of the PTR will plainly be costs in the case. Are there any applications or submissions in relation to the costs of the 2 applications for documents and further information?
Your Honour, we say that we're entitled to the costs of the request for further information. Now, we accept that we have been unsuccessful on request 6. As far as the other 2 are concerned, Your Honour has made a direction or an order in relation to request 7, and request 8 has been satisfied subsequent to the issuing of the application, and largely because we have issued the application, including 2,000 odd documents arriving on Wednesday night. It's clear from the correspondence that those are documents that weren't promised in advance of or they include documents that weren't promised, but were a response to us saying, this is what we want. So we say that we've been substantially successful on that. And insofar as no order was made under request 8, it was only because they had effectively done what we'd asked them to do. As far as the application for information is concerned, it has been dismissed, but it was never responded to. And on the basis of the rules, it was perfectly proper to us to issue the application if someone doesn't actually respond to it and explain why it is improper in writing in accordance with 19.19.1. So whilst your Honour may say, well, I'm not going to give you your costs of that application, it certainly should not be the case that we pay the costs of the information application where there has been a failure to comply with the rules and respond when it has been set out in writing in advance. That's a very quick overview.
Mr. Barrow.
Your Honour will not be surprised here. We would ask for our costs to be assessed if not agreed in respect to both applications. Your Honour has refused request number 6 as well as request number 8. Your Honour has been critical of all of the requests for being far too broad in the way in which they were drafted. I accept that an alternative has been suggested in respect of request number 7, but is not an alternative that the claimant has proposed or ever engaged with. The reality is, from the 12th of September, which is the point at which they could have issued this application, up until today in February, so we're talking 5 months, the formulations have not changed. And the simple submission is that they have not succeeded on their application for document production. And on the one request that Your Honour has made an order on, it's not at all reflective of what it is they actually asked in the formulation. In respect of request number 8, I don't agree with my learned friend's assessment because, quite frankly, we told them the categories of documents we were going to providing them. The facility agreements and the security documents are the main ones. They've never sought to engage with us. We are the only party that has consistently and constantly tried to engage with the claimant to narrow the field down, and we voluntarily produce requests. They could have agreed to dispense with this hearing and save the costs of actually having to attend weeks ago. But they've simply failed to engage and they've gone full steam ahead. So we say we should be entitled to our cost of the document production. In respect of the further request, clearly they are the unsuccessful party. And I don't quite follow the submission, which is, well, if you don't respond, we're entitled to bring it. An unmeritorious application is an unmeritorious application. And on any reading, and the claimant ought to have been able to determine themselves that 2 of the questions they were asking had already been answered in the pleadings. And the other 2 have no relevance, and they are plainly matters if they want to explore, are appropriate to explore for trial. So again, they've pursued an unreasonable application that has been wholly dismissed. So the appropriate order, Your Honour, in my submission is that the claimant pay the defendant's costs of both applications to be assessed if not agreed.
I'm going to deal with principal costs, and I'm going to ask Mr. Adair to respond, but just as a matter, I've got a statement of costs from the claimant. Is there a statement of costs from your client, Mr. Berry?
I haven't seen one, Your Honour. I'm just asking for confirmation. No, there isn't.
I think you should have provided a a statement of costs, but we'll deal with that in. Yes, on the principle of costs, Mr. Adair.
Just a few additional points. I've set out in my skeleton why we say that there was a delay and failure to respond adequately to the requests for documents when they were first made. That delay has brought us to a situation with the trial becoming very, very close, where this issue had to be resolved, and that application had to be issued. So that delay forcing us to, at the last minute, as it were, having hoped that we would actually be able to negotiate a settlement of this, and all the other issues were resolved satisfactorily, but there were a total of 9 requests to start with. That delay is relevant to us having to issue this application, and my submission is, when you factor that in, the fact that they've complied with request 8 somewhat belatedly, request 7 was successful, request 6 wasn't, we accept, and they just completely broke the rules and failed to respond on the information request. In my submission, those do militate in favour of a cost order being made in our favour.
The 2 applications have been made by the claimants in relation to this matter. One is in relation to requests for document production, and one is in relation to additional information under Part 19 of the rules. So far as the Part 19 request is concerned, it seems to me that there was never a proper basis for the requests which were sought. I accept that the claimant did not identify as clearly as it might have done in response to the second letter, which made it plain that it was a Part 19 request, that there was no proper basis for it. However, it seems to me that in relation to that application, the claimant proceeded with the application and has not then or now satisfied the requirements of the rules, and therefore it is appropriate that the defendant have the costs of that application. So far as the orders for document production, I regard the defendant as having been the substantially successful party, because it seems to me that none of the requests as originally formulated were granted. And it also seems to me that it is very important that parties in this jurisdiction understand that the formulation of the requests is extremely important, and making overbroad requests is likely to lead to just the sort of situation we have now. Having said that, the claimant did achieve a measure of success in relation to one of the 3 requests it put forward by way of a reformulation. And it is also fair to say that there have been a substantial number of documents produced after the request was issued. In all the circumstances, it seems to me, as I say, that the substantially successful party is the defendant. However, in the case of the application for further documents, it seems to me that the appropriate order is that half the costs should be payable. I would have liked to assess the costs now because it would have been appropriate to do so, but in the absence of a statement of costs, I can't do so. And therefore the costs will have to be assessed if not agreed in accordance with the order that I have just indicated. Right, gentlemen, thank you very much. Is there anything else which
sorry, Your Honour, I guess my learned friend and I are going to have to formulate request 7, as you indicated earlier. So do you want us to formulate that and then send it to you for the purposes of an order?
I'd like you to agree the formulation of request 7, as I indicated, I think, during the course of argument. If you can't agree it, I will settle it. But if you can agree it, so much the better. I hope it's adequate from what I said during the course of argument. If you can't agree it, you better tell me quickly so I can remember what it is that I formulated.
And how would you like us to communicate that formulation?
Through the registry, please.
Registry.
And sorry, Your Honour, just for my own clarity, because I don't think I took a note properly. Is it 50% of the defendant's costs of the document production application?
Yes.
Yes, I'm grateful.
Yes, you get the whole of the costs to be assessed if not agreed of the part 19 and 50% of your cost of the document production.
Yes, I'm grateful.
Good. Well, I look forward to seeing you in Dubai on the 10th or 11th of March.
Thank you, Your
Thank you
Honour.
very much indeed. Thank you.